just like a background of like how the claims work.
Yes.
So I'm trying. This is a little technical. I'm trying not to make it too technical, right? Quick, a little bit of history, right? So in 1871, we're going back, right? Wait, 1871,
right?
And during Reconstruction, the KKK is running rampant throughout the South, and they're killing black people and murdering them, slaughtering them, and they're depriving them of their constitutional rights. And back then, you had no way to bring a claim in federal court because and you can't bring it in state court because the KKK runs the state court,
right?
Right. So I mean, that's their territory. And you're not. If you get in state, you don't have the juries. The jury's going to nullify anything. You don't have the judges. You don't have the legislatures. You know what I'm saying? So you got no recourse. So the 1871 Civil Rights Act, what that does is that says you have a federal right to sue in federal court for a constitutional right violation. That's the first time that happened. Okay, so that's the history of why you can sue in federal court. But that means that federal court has its own separate set of laws than the state court. So each state is going to have the civil rights laws that are going to be based on what they call common law, which is the old English law that was carried over from Britain when the United States was formed. So they all have different variations in it, and then the federal law is realistically has about a little variation too. So the 12 different circuits of federal court, and each circuit has a little bit different, quirks that they do. And the Supreme Court is
liberal circuits.
Yeah, liberal circuits. You got conservative circuits. So that makes a big difference.
And when you're saying circuits, you mean like the state, or the area?
Yeah. So federal courts are divided into 12 geographical areas of the country, and it's so in New York right now we're in the Second Circuit. In Philadelphia, where I'm from, shout out to Philly, it's the Third Circuit, right? So it's basically Texas is the Fifth Circuit, California is the Ninth Circuit. So that means that all these different circuits, they all have their own set of laws a little bit. And they're supposed to match, but the reality is the Supreme Court doesn't take up these cases a lot, so it's not going to match.
Yeah. So basically, what happens is, and it's the same thing in state court to a certain degree, where that basically these circuits are going to develop like law over time, and those laws, if they don't make it to the Supreme Court, it will control how cases get handled in that circuit. Because they will have made decisions that if those decisions are appealed to the Supreme Court, the Supreme Court decides to take it, it won't be applicable to all the circuits. It'll just be in this circuit, this is what they do based on this decision from the circuit.
Now you may hear that, you can say, well, what happens when Circuit A says one thing and Circuit B says another thing? Well, technically, the Supreme Court is supposed to decide that, but the Supreme Court's not going to decide that. Why? They only take 50, 70 cases a year. Most of the cases are they're gonna take an abortion case every year, right? So regardless of what everybody feels about it,
they got 49 cases.
They say it, right? You gotta say that for the abortion. No matter, no issue, nothing's on the table. We just gonna take an abortion case because we just gonna keep trying to tear it down. So so they got their own political stuff they care about.
Right.
So it's 50,000 cases that the Court of Appeal, the whole circuit Court of Appeals decide. So you're going to go from 50,000 to 50 or 60. So realistically, what happens is that if it's in the Court of Appeals, they kind of make their own law. They're only really going to be reviewed once every 10, 15, 20 years. And so, and that's not going to help you out.
So are there certain circuits and even some states in which getting a successful civil rights case is dramatically harder than, let's say, a liberal circuit?
Yeah, so you have the worst circuit in the country is considered the Fifth Circuit. I think that's Texas and Florida. And then,
how is Texas and Florida even close to each other?
I'm thinking circuits like wires, right?
Yeah.
How are you going from one state to another? How do those two states become
it's the Fifth Circuit? I think it's Florida. Let me double check that.
Yeah.
But they're just wild. They're wild. Yeah, they just do whatever they want
and get away with it.
Now, sometimes they do, sometimes they don't. The issue is that they're wild. They just kind of the qualified immunity is everything.
Right.
It's everything. it's really difficult. It's tough, and that's crazy because you're talking about what, like, 40 million people or something like that in that area. That if you have the Ninth Circuit, California obviously is considered pretty good, right? Second Circuit, Third Circuit considered pretty good. So, which is New York, So, the reality is that the amount of rights you have depends on where you live. And if you live in a blue area, you get more rights, and if you live in a red area, you get less rights. And I don't know why people don't tell you this, but it's the truth. Like, that's just the way it works. So, like, if I'm in, and again, you're a lawyer, so you gotta look at cases. Like, so if I'm in Texas, I'm doing that case fine tooth comb. If I'm in New York, I'm like, all right, maybe I'll take a risk with it. But I'm not taking a risk in Texas. I'm just going to waste money. It's a type of thing. Like, yeah, you got to know you're in a bad district. You got some judges that are just like, they're not up here. I'm not gonna get my mess up me. They'll be like, oh, besides talking about the judges. No, y'all good. I'm just saying that.
Listen, man, through experience, like this guy, I don't know, man. Last time I was here, you didn't offer me water when I was out, so it doesn't seem like that. That being nice to me.
Yeah, I got a good track record, in getting motions and winning motions. And part of that is just understanding how to frame arguments, right? Because it's like, if you say it one way, you lose. If you say it another way, you win. And you gotta say it the right way. It's not really a fact thing. It's like how you interpret it, right? Was a cop, like, I'll just be like, okay, was a cop like negligent? Did he just make a mistake, or did he intentionally do it because he was trying to like hurt my client? One, case gets thrown out. Two, case keeps going. Right. So you have to make sure, like, I gotta plead this in a way. Some lawyers aren't comfortable with that. They're not comfortable saying cops lied, cops, they're not telling the truth. So, their cases get thrown out. I'm here to win, so I'm not worried about that stuff.